So Ian Gige Njoroge, hereinafter referred to as the accused person, a young lad who was thrown into a particularly hellacious stage of his life in what William Shakespeare described or rubrics, and I quote, all the world's a stage, end of quote. The accused person was arrested and arraigned in court on the 4th day of June 2024. He faced 3 counts before this court. The first count was for the offense of robbery with violence contrary to section 32962 of the Penal Code, where it was particularized that on diverse dates between the 2nd day of June 2024 at Committee Road in Kasarani, sub-county within Nairobi County, jointly with others not before court, robbed number 67839 Koplo Jacob Ogendo of a battery of police communication gadget and a mobile phone, make Samsung Galaxy Note 1 valued at Kenya shillings 50,000. And immediately after the time of such robbery, wounded the said number 67839 Koplo Jacob Ogendo. The second count is for the offense of grievous harm contra section 234 of the Penal Code, where on the 2nd day of June 2024 at Committee Road in Kasarani County within Nairobi County, unlawfully caused grievous harm to number 67839 Koplo Jacob Ogendo. The third count related to resisting arrest contra section 253B of the Penal Code, and it's that on the 2nd day of June 2024 at Committee Road in Kasarani sub-county within Nairobi County, resisted arrest by number 67839 Koplo Jacob Ogendo, who at the time of the resistance was acting in due execution of his duties. The accused person pleaded not guilty to all the 3 counts. The learned prosecutor then, Ms. Kariuki, intimated that the prosecution will wish to oppose the accused person being admitted to bond or bail. She sought for time to file an affidavit in support of the said application. The defense counsel, which included Mr. Okach, Mr. Lempa, and Mr. Echesa, vehemently opposed the prosecution being granted time. Their gravamen was that the prosecution had not demonstrated compelling reason not to grant the accused person bail or bond. They decried that the accused person's rights were being violated from the time of his arrest, during his arraignment at the police station, during his detainment at the police station, and similarly upon his arraignment in court prior to its commencement. They contended that the accused person had injuries sustained after being assaulted. Ultimately, the court granted the prosecution a day to file the said affidavit. The prosecution filed an affidavit in support of the application, and it was sworn by PC Josephat Rotich on the 5th day of June 2024. The grounds deposed in the affidavit are succinctly set out therein. The application was conversed orally. The prosecution was represented by Mr. Owiti, Mr. Gashoka, and Ms. Kariuki, whereas the accused person was represented by Mr. Okach, Mr. Lempa, Mr. Echesa, and Mr. Ndegwa. Mr. Danson Omari and Ms. Sophie Nekesa appeared for the complainant, Koplo Jacob Ogendo. Mr. Owiti, learned prosecuting counsel, reverberated that the state opposed the accused person to be released on bond for the reason that they are compelling reasons. He urged that the yardstick and the touchstone to be applied in determining the application are contained in Article 49(1)H of the Constitution, Section 123, and Section 123, capital A of the Criminal Procedure Code. Similarly, the doctrine of stare decisis, and also the Bail and Bond Policy Guidelines 2015. He preempted the defense argument that the right to bond or bail is a constitutional right. However, he was quick to adduce that the said right was not absolute, as it is limited in line with Article 24 of the Constitution on the limitation of rights and fundamental freedoms. He propounded that inasmuch as the defense would want to ascribe the presumption of innocence, he submitted that the Supreme Court of Kenya had pronounced itself that the denial of bond or bail is not a violation of a fair hearing or the presumption of innocence. He argued that it is a matter of public notoriety that the complainant is a law enforcement officer, and that a person who has the temerity to assault a police officer commits a very serious offense against the state. He anticipated that the defense will argue on the wrongness, but urged the court not to be swayed by that. He exaggerated that the application is in the interest of justice and the administration of criminal justice. He urged that the court to rise to the occasion and send a warning to